Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Yes, I did, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Street.
Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 before Judge Slate Thursday.
June 27, 2024, 1:30 Slate Thursday.
In the beginning, the judge confirms that Mr. Ruggs has signed a waiver, meaning he is giving up his right to a preliminary examination. The judge explains that this hearing would normally decide if there's enough evidence, probable cause, against him, but since he waived it, the case will move directly to circuit court. The defense accepts the charges formally, stands mute, and the judge enters a not guilty plea on his behalf. A pre-trial date is then scheduled for June 27th.
Bond with its conditions will continue. Yes.
Report the note in my file from the other APA that you saw in violation review that's today.
Yeah.
I have the May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lives in Macomb County. We
I'm on GPS. Oh,
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm going to fail for would be marijuana.
Why are you using that?
The judge brings up a bond violation report, asking why Mr. Ruggs misses drug testing. The defendant explains that he was confused and thought he needed a court order, and no one told him where to go. When asked if he would pass a test today, he admits he would only fail for marijuana. He also opens up about his past cocaine addiction and recent personal struggles, saying he's been trying to cope.
Can I speak freely?
Yes.
Your Honor, I'm going to be up for honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've helped to
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's going to happen, and then we'll figure out. In the meantime, counsel can prepare an order so that he can test in Macomb. Okay.
And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not he'll be remanded.
Pardon?
The waiver's all set now?
Well, technically, no.
Got it.
Because, technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're going to do.
Okay. Thank you.
The judge decides to send Mr. Ruggs for immediate drug testing at community corrections. The judge says he will review the results before deciding what happens to his bond. Meanwhile, the defense is told to prepare an order so the defendant can test in his local county going forward. The situation is left temporarily open, depending on the test results.
Thank you.
Thank you, Your Honor. Nicole Hughes on behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who was present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's no contact with her. In that, in addition to the corrections violation, I'm requesting that he be remanded and that his bond be revoked.
That's not my problem.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
As the hearing ends, the prosecutor informs the judge that the defendant was seen sitting and talking with the victim, despite a strict no-contact order. The defendant admits she was sitting next to him and that they spoke. The judge takes this very seriously, stating he clearly violated the rules. As a result, the judge immediately revokes his bond and orders him back into custody, ending the hearing.
Does he admit to the violation?
You're on. Much faith.
If you wish.
She wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something that I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Okay, I
So-
understand that. Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. He'll just go up before Judge Slay. I'll just leave it there.
Thank you.
Your Honor.